and sources of criminal litigation. So we start by looking at the first one, meaning of criminal litigation. So who knows what criminal litigation is? What is the meaning of criminal litigation? What is the meaning of criminal litigation? I did emphasize that during my preliminary lecture in this a few of you who were around. What is criminal litigation? What do you mean criminal litigation? Nobody knows. Even the people who just spoke to us now. What is criminal litigation? We're looking at the meaning. What's the meaning? Criminal litigation. Your heart is still at home. Yes, go ahead. Litigation is a process whereby a suspect against whom a prima facie complaint has been made is a process whereby a suspect against whom a prima facie case of the complaint made against him has been established is arraigned and tried in the court of law. Is arraigned and tried in the court of law, and also given the opportunity of defending the allegation against him. Also giving the opportunity of defending the allegation against him. You know why we have a shift from criminal prosecution or criminal procedure to criminal litigation is that when you talk about criminal procedure, it gives the impression that all you're doing is prosecuting and invariably persecuting the defendant who was erstwhile called the accused person. Right. So the tenets of fair hearing depicts that in such a trial, there must not be anything that will give the impression that this person is under a burden of trying to discharge himself from any allegation of crime. No. That's why the Constitution has presumed him innocent until the contrary is proved. So that presumption of innocence entails that when he comes to court, when he is arraigned, he comes to court unfettered. You don't put him on handcuffs while he's still in the court. Once he comes into the hallowed temple of the court, that fetters must be removed from him. It's part of showing that his presumed was innocent, and he is treated with kindness. First of all, by the time we look into the trial proper, you understand better. He comes in, gets into the dock, the charge is read to him, and before the charge is read to him, he is put to an election. Do you want your mother to be tried now or in the high court? He elects where he wants to go. So at least for the purposes of that, he's a big man, not a criminal. The policeman says, oh, we have caught the criminal. Because there is an allegation against the person saying have called the criminal. No, that is wrong. And then also, you read the charge against him and allow him to take a plea. You do not presume that he has committed the offense. Just like oftentimes is done within the police sector. Once a complaint is laid, as far as they are concerned, they are on the side of the complainant. But criminal litigation balances the question. Criminal litigation takes into focus the immortal words of Okuta JAC, which says that justice is a two-way traffic. And at times, with a three-way traffic, justice for the accused or the defendant on whose neck hangs an allegation that will damn both his future and his reputation. Justice for the state that try to ensure that there is orderliness, in line with the social contract as postulated by Rossi. And justice for the victim, who had maybe he's dead, and whose blood flies to the high heavens for a recourse. So that is why we are talking. That's why the change in the face of criminal prosecution has been made to make you look at litigation. You know, litigation is adversarial. You say your own, I say my own. Bring your evidence, I will bring my evidence. So that is the fulcrum and the point at which that very deduction is made to balance the fact that yes, this person is actually presumed innocent, is not presumed guilty. And then you also want to look at what's the difference between the criminal law, which also going to look at, and criminal litigation. Criminal litigation is not criminal law. Criminal law comes into effect when a suspect has been accused. Is accused based on criminal law. When I talk about criminal law, I'm not simply referring to criminal code. You understand that in the course of this discussion. I make reference to every law that creates an offense or creates offenses. It's not only criminal code or penal code that creates offenses. No. Now, when you talk about that law that creates offense, that is the law on which the prosecutor or the police looks upon to be able to judge the conduct of the suspect, to know whether there is a private facial case that he has committed an offense or not. And when there is unreasonable, suspicion or prima facie evidence that he might have committed an offense, he is arraigned. When he's arraigned, another thing comes into effect. The criminal law is there judging him, and then what regulates the proceeding is what? Criminal litigation. In other words, criminal litigation is procedural, while criminal law is substantive. That is the adjective law, the adjectival law. So that's the major difference between both of them. And then we now want to talk about scope. When we talk about scope, based on the question you were asked, discuss the meaning, scope, and sources of criminal litigation. Scope of criminal, what is scope of criminal litigation? In other words, the scope of this criminal litigation involves three basic things. The first one is the act of investigating a complaint. The second one is that adjectival law, the substantive law that you're going to apply. And the third one is what? Have you forgotten? The procedural law. This is the scope. So even from the meaning, you can derive the scope. So put it better or to expatiate on this, talking about scope. We look at the adjectival law in the scope. Naturally, you may want to say, okay, because you did criminal law, what naturally comes into your mind is criminal code or the penal code. You are right, but that is still 1%. Because there are other various laws that have prescribed offenses. So that is part of the scope we are talking about. Those body of laws. For instance, custom and exercise. Under custom and exercise, if you smuggle goods, you have committed an offense. When you are being charged in court, the law that is applicable may not be the criminal code. It will be basically what? The principal law. What is the principal law now? The Custom and Exercise Act. Alright. What about somebody who is a public servant who has violated the oath of office? The ICPC Act comes into focus. Or somebody has committed financial crime. That's when the EFCC Act comes into play. We can go on, and in these days that we are now linked to every part of the world through the internet. You can as well talk about the principal law that prescribe offences for internet crimes and frauds. Which law is that? Cybercrime. Say it properly now. Cybercrime. What is cybercrime? What is the law?
Cybercrime Prevention Act.
Don't write your project concern that area. Give me the full law.
Okay. Cybercrime Prohibition and Prevention Act 2015.
Prohibition and Prevention Act 2015. Right. So these are the laws that will definitely come into play in order to do what? To interface with the procedural law. So it's not every time that somebody is charged that the person is charged based on criminal code. What about professional ethics? A lawyer commits an offense that is not becoming of a lawyer, or that constitutes what? Misconduct. You try him based on what? Rules of professional conduct. Right. So those are things that come within the scope. And as well as any other law that may be made by the National Assembly. And then we talk about the complaint, which is another stream that comes within this scope. Complaint. Complaint is made by a citizen against a fellow citizen or against a corporate body, complaining of violation of his right in such a manner that it constitutes a crime and an offense under the law. What is the difference between an offense and wrongdoing? If somebody does something that is wrong, maybe somebody comes into your land, trespasses into your land, is that a crime? No. It's not a crime. It's not a type of thing that will make you to write petition to the police. That is what civil wrong. So there is a difference between civil wrong and criminal wrong. But both of them are wrongs, which are acts contrary to law. But what is the underpinning? What is the dividing line? The dividing line is that in criminal offense, there must be one penal or penalty. That penalty is what distinguishes it from what? From the civil wrong. Civil wrong, the recourse is what? Damages. Compensation. But this one is fine, imprisonment, that is penalty. And when this complaint is made, what is basically the attitude of the body receiving the complaint? Most of the times too, when you hear complaint, you think complaint is made only to the police. No. But because we are so much used to in a police society, that's why we now take every complaint as emanate from them. If it's a lawyer, you report to what? The disciplinary committee. A medical doctor, they also have their own disciplinary committee. Right. If it's a wrong against the customs, you go to customs. If it's a wrong against pipeline, maybe Shell pipeline, we have Shell police. You can very well do what? Report to the Shell police. Or if it's a general wrong that pertains to violation of order and security of the entire society, you go to the police. When such thing is reported as a complaint to the police, what is the duty of police? What is the police expected to do? Arrest you? The answer is no. But what we see here is they will be arrested. They will arrest you, talk about that money and so on and so forth. But in a set line, a complaint is investigated. This person did this. They will take their time to find out whether this person actually did it. And that's why in the Western world, if you watch crime and investigations like I do, you will discover that an offense will be committed. And this person will be working spot-free. They have received, the police have received the complaint, but they have not taken steps. They will be watching to make sure that this complaint is not subject, it's not something to prejudice the person against whom the complaint has been made. Because it's possible that you may be witch-hunting somebody. So what they mean is that they want to make sure that this person has committed the offense, and they start gathering their evidence. And secondly, they are wary of the fact that if they arrest you and that arrest comes to be wrong, there will be penalty against themselves. Do you understand? And when a policeman, for instance, in the US or UK, behaves recklessly, in the end the state pays, and the policeman will remain in service, your money will be deducted until you have paid fully and you are discharged. And when you are discharged, you leave the police without a badge. That's the difference between the police and our own police. Badge means everything. Badge is anywhere in the Western world. That's why maybe you see these footballers when they kiss the badge because it's symbolic. Right. But here now, no investigation. The next is that they will arrest you, and if the other person comes and bring money, you will see them go to court and mess up the case. Even when there is prima facie evidence that this person committed the offense. Why? Because they are not prepared. Alright, that's talking about the scope. In the course of this discussion, we'll also look at other ingredients of that. Now, if for instance, let's assume the police have made their investigation, and after investigations, they were convinced that a crime has been committed, they can then arrest. Except if, for instance, they believe that this person may escape if they continue investigating maybe for a long time. Under that situation, they not allow them to do what? Take the person into custody. But there is a time frame. If within 48 hours you can't charge him to court within 4-kilometer radius of the police station, what do? I meet him on bail, have a shorty on him. In US it's called get a bond man. Somebody pays the bond. If the bond in the end is succeed, the bond is returned. So like now you are arrested and say, well, I'm calling brother, that no. And the miniature that we have there is what we call charge and girl. Maybe somebody who is not even a lawyer comes to sign for you. There's nothing wrong with it. So long as that person is somebody of trustworthy character, that is what he's doing in the US. You must have somebody to take you on board, whether he knows you or he doesn't know you. He's in business. He's taking a risk. Right. So when the situation is such that this person may run away, what you do is that you check it and then you do what? You grant bail. And after granting bail, the investigation can also continue because our law doesn't allow you to charge a suspect to court. After you have charged him, you say, my Lord, I want him to be remanded in prison because we are still investigating. No, that is wrong. That's what is called holding charge. And the Supreme Court has held for the opting time that holding charge is wrong. Anytime such a thing is being done, mind you that what the police is trying to do is to embark on holding charge. And holding charge is unknown to law in Nigeria. It's purely illegal. Once you charge the person to court, you have charged the person to court. If you have additional evidence, bring it while the trial is still going on. Right. When a person is apprehended, he is meant to volunteer his statement in writing. So if you are educated enough and you can write, nothing stops the police from. Of course, it will be your right to do what? Tell them, give me the paper. You will write. You are not to be coerced. But what we see in most cases is that because the police want to secure conviction or they want to intimidate you, they will write and ask you to sign. If they ask you to sign, tell them no. Look at the constitutional rights of accused person. They are about 10 for 13 of them. You make use of it. I want to see my lawyer. You have a right. The law says that you have a right to a counsel of your choice. The law says that the offense against you must be spelled out and you are made to understand it. And that you begin adequate to prepare for your defense. As many constitutional rights as you can see in the Constitution. There was this particular case, like I said, this matter, I'm also going to be sharing from experience. This matter I did for a former student, you know, and there was need to have two interpreters. The first interpreter was a Fulani man who couldn't speak English. So he would communicate with the suspect, the defendant. So he spoke in Fulani food there with the defendant, and then spoke in Hausa to the man who understood both Hausa and English language. So there must be that nexus. So if you have a situation where there has to be cross-lingual differences, you must ensure as a constitutional right that every language presented there must be what? An interpreter. And if there is no interpreter, the entire exercise will be what? Will be acknowledging. The entire exercise will be acknowledging. Then we'll talk about that arraignment trial. The other ones I don't want to bother because by the time we start discussing the bits, we'll have enough time to discuss what the charge is, what bail is, what trial options, what trial against are. As at the time we come there, we'll discuss about them. Now the next thing is sources. Sources of criminal litigation. There are two basic sources of criminal litigation. We have the principal source or sources and the secondary sources. But what you discover in principal sources is that the Constitution is not a principal source of criminal litigation. Who can tell me why? I mean, the Constitution is the ground, but it is not the primary source of criminal litigation. Who can tell me why? Powers, institutions to create your offenses. So it can't be a principle. For instance, you see a question as a discourse. I think maybe the next lecture, if I remember, I'll just come with one script that depicts how not to write exam at this level. How not to write it. At times I try to make you pass, you say no, let me. All the principal sources. We talk about legislation like Administration of Criminal Justice Act. That's at federal level, 215. AJA, 215. Administration of Criminal Justice Act is the principal legislation of criminal litigation. And it is the law that repealed the Criminal Procedure Act. It repealed the Criminal Procedure Act. I see them still mention CPA here. In case you didn't look at it. Most of the things we'll be studying here, I'll be coming to class with Aja. I done all of them. And is maybe a federal offense. And it's committed in Abia State. And the federal attorney general is interested. And he wants to be the one to prosecute. Which law will guide him? What is your thought? Philosophy behind prosecution of offense is to ensure a safety environment. But with the caveat that it is better to let 99 criminals go free than convicting of one innocent person. Now, if the case is in a state high court, maybe it's a matter that is within the concurrent jurisdiction of both the state and the federal high court as far as it's a criminal offense, and the federal attorney general wants to come, you will be bound by what? Our law. Do you understand? You can't come to our high court and you're citing your federal law now. Is it possible? But if it's an offense being tried at the federal high court, yes, we can cite and rely on federal law. But most times what they do is that in order not to create chaos, what they say is that he calls his brother attorney general of the state who will take over. There was a time when the state could not even handle the case of armed robbery and illegal possession of firearms. the state had no jurisdiction. But because of time, they said, no, we are shooting ourselves on the leg. Why would we want to sanitize the society? And we are doing ourselves this favor by what? By bringing in technicalities. Why would we do that? Because of that, they said, because there is no place called federal territory except FCT that is clearly marked. Do you understand? It's just like everywhere is within the Federation of Nigeria, but everywhere belongs to somewhere. At times, the local government people will say, give us money, we want to do this, not that. As a matter of fact, if we have to look at it critically, the arm of government within the state that has the duty to build roads, do this in our the local government. Everywhere is within the local government, am I right? Everywhere is within the local government. But for ease of administration and to avoid some cantankerous characters, there are some people who give that power. They will take over and go and get out. How much are you receiving? Do you understand? Then there will be that problem. So because of that, they said once is an offense, you will treat it as an offense. So no offense will be discontinued simply on the ground that it ought to have been charged under federal law, but it's charged under state law. So long as the state high court has what jurisdiction, is a different thing. If it's an offense outside the purview of the jurisdiction of the state high court, that's when that argument will hold water. And then we'll have series of other laws coming under it. If a parastatal is created by an act, and within the act, some certain conducts are criminalized, it means that that act has become what? A principal legislation. And it has become what? A principal source of criminal litigation, like EFCC Act, ICPC, Custom and Excise Act, too numerous to be mentioned. Right. Then we look at the secondary. The secondary laws are those laws that do not directly deal with procedure. Do you understand? They don't do with the procedural law. Rather, they are the substantive law. They are the substantive law. They have nothing to do with procedure. They are the substantive law. For instance, some of these laws that I have mentioned now. For if you read EFCC Act, you will discover that there is something that Act tries to do. The Act verses on itself both the procedural power and what the substantive power. I mean, to tell you in the course of this investigation, EFCC can do what? Can seal a premises. EFCC can do what? Can confiscate. So it is both a principal legislation and what? Procedural legislation, because it tells you the process, what to do. Are you understanding it? So it's different from that law that simply talks about clearly offenses, no procedure, not to be done. It doesn't tell you what to do when such a thing happens. But it simply says, if this happens, it becomes what? An offense. Now, such laws include the criminal code. Criminal code will spell out every offenses, some of them that are even archaic, that have also been replicated in another law and in another form. Then you have the Evidence Act. Does it have anything to do with offense? Evidence Act, you can tell me. Does Evidence Act have anything to do with an offense? Right, tell me. Talking about criminal and what? Civil. You now understand standard of proof, but it doesn't tell you how. Do you understand? He said if maybe you want judgment to be entered into your favor in respect of civil, then you must be the one to do what? To prove. How do I prove? Is your business. So if the Evidence Act has said do this, do that, we also bring it under the purview of what? Procedural law, but it hasn't done that. Then you stop at Evidence Act 2011, that is wrong. You also need to bring in Evidence Amendment Act of 2023. It's an integral part of 2011. It didn't repeal 2011, but it's like a continue. It's a continuation of the 2011 Act. We have talked about the Constitution, and then we have other like so a lot of states also has its own criminal laws, criminal code laws instead of criminal code act, criminal code laws, penal code law, armed forces act. These are, the law that as young persons, Children and Young Persons Act. These are secondary legislation. In that they do what? They tell you about the act that constitutes what? Offenses. Let me see another thing. Other law which attach punishment upon commitment or upon committal. By so doing, you have expanded your frontiers. You are not only, beating back to the microcosm of what, talking about only the criminal code. What you have written down, you have expanded. All right. Then when you are talking about various processes, various stages, you are talking about. You talk about pre-trial stage. That is wrong. Some textbook they say that, but that's not correct. Because the proper thing to say is pre-arrangement. Pre-arrangement has to do with anything that has to do with the police. Or you call it extrajudicial stage. Either the extrajudicial stage or the pre-arrangement stage. That's when complaint is made, investigations are done, and arrests are made depending on the outcome of such investigations.